What's up, everybody? Clint Powell again here with Eric Buchanan and Associates. It's time for another one of our deep dives. And I always like to tell people before I bring Eric up is I'm a little biased. I have used Eric and his team in the past. Yes, when I got denied for some claims, and mine was a high ticket item. I was a little worried. Went to Eric. He said, "I speak insurance. My team speaks insurance." And I've been friends with Eric for a long time. And these deep dives are a lot of fun for me because Eric's a smart guy, and it brings in some history. Plus, I learn a little bit, but it's also very informative. We're addressing things that will affect you directly. So let me do this. Let me pull this off the screen like that, and then I'm gonna bring Eric up in 3, 2, 1. What's up, Eric?
Hey, Clint, how are you? Good to see you.
I'm good. How are you doing, buddy?
Wonderful.
All right. Well, I have in front of me what we're going to be talking about today, and we stick with ERISA. And there are certain rules that the Department of Labor has in place that a lot of attorneys don't know about. They're there to hold the insurance companies accountable and to help us common folk. Did I kind of summarize that okay?
Yeah, these regulations we're going to talk about today are the regulations the Department of Labor has put out that helps people who have ERISA claims. I don't know how many attorneys know about it. No, I have run into some attorneys who don't know about these regulations. I've had to teach them about them. Plenty of attorneys do learn about it if they start to handle ERISA cases, but it's basically it's the simple rule book for how an insurance company is supposed to handle somebody's ERISA claim. So first of all, what are we talking about? If you have your insurance through work, it falls under ERISA, the Employee Retirement Income Security Act of 1974. Almost always, if you have your insurance through work. Occasionally, if it's a government employer or sometimes if it's a church employer, it might not fall under ERISA. But for everybody else, for their health insurance, their life insurance, their disability insurance, if you have your insurance through work, it falls under ERISA. And so the U.S. Department of Labor has put out these regulations we're going to talk about today that say if you get your benefits through work, here's the rules the insurance company is supposed to follow.
Okay. Well, I want to encourage everybody because I did mention this in the intro. These are fun and they're full of history and facts, and you mingle it, you intertwine some need to know stuff in them. I encourage everybody to go look at the video we did 3 or 4 before this one. It's the history of ERISA and how it got started, how it got kind of hijacked. That was a fun podcast and a video. So if people are wanting a more of a like, what, how did it get started? And where kind of did it go off the rails? Did it go off the rails? That would be a good video to go watch. So,
Yeah, and
all right.
it's good to just quickly mention the summary of that one. If people, I definitely would encourage people to listen to that podcast if they're interested. But 1974, Congress basically decided to write a federal law that was going to protect everybody's pension benefits. And at the last minute, they added rules to say that this federal law would also protect people's other employee benefits. So not just your pension, but your health insurance, your life insurance, your long-term disability, if you get that through work. And that's part of what has made this ERISA stuff so confusing is that what people have, they think hey, I've got this disability insurance policy. They go to an attorney, and the attorney sometimes doesn't know about ERISA and says, oh, well, this looks like a breach of contract case. I'm going to go file in federal court or I'm going to file in state court and sue this insurance company for breaching your contract. And it turns out, no, it was subject to ERISA and a totally different set of rules apply.
Yeah, and part of that is there's deadlines, things that are really can affect the outcome of that case that if you don't know about and you fly right by, trust me, the insurance companies do know about them, and they're kind of counting on, at least my opinion is, I think they're counting on people like me to leave it on the dining room table for a while, do what they normally do, and they send in, no, I'm completely disabled. What are you talking about? And 3 months or whatever the timeline is goes by. So, all right, so talk to me. Where do you want to start about these regulations and the rules that the insurance company are supposed to play by? What do you want to start with this?
So before we dig into the regulations themselves, I'm going to put out two big picture kind of overview things.
Okay.
One is that every ERISA policy can be different. Your long-term disability and your health insurance that you have at your work are different from the next man or woman's disability insurance or health insurance they have at their work. And the rules that you have to follow to file a claim and to go through the steps and to decide if you're entitled to the benefits, if you decide if you're entitled to disability or life insurance benefits or to have your medical expenses paid can depend on the language in those policies. And the other big rule is that if you have a claim, you have to submit everything to the insurance company for the insurance company to consider before it goes to court. So those are two big rules that kind of overlay these claims regulations. And what the claims regulations say is when you're going through that process of appealing to the insurance company, there's certain rules the insurance company has to follow. One big rule is that they have to comply with their own regulations, their own rules inside the policies, inside the ERISA plans, inside the documents that say what the rules are for this particular plan. But they have to meet certain minimums under these regulations, and that's what we're going to talk about.
Okay. So in other words, they're supposed to play by the agreement they have with you. And then on top of that, there's certain things they've got to play, like the bumpers are up on the bowling lane. They're supposed to stay inside those bumpers.
That's a great way of putting it. They have to stay inside those lanes.
Yeah.
So to get nerdy, if anybody wants to go pull this up on the interwebs, on the internet, it's
Yeah.
29 CFR, and CFR stands for Code of Federal Regulations, 29 CFR 2560.503-1.
No one wants to get nerdy, but go ahead. I mean, go ahead,
That's where
Eric.
you go
That's fine.
find these claims regulations, and there's multiple parts to them. So the Department of Labor originally put out claims regulations in the late 70s, early 80s. They've amended them multiple times. There was a big change. The whole claims regulations were rewritten effective in 2001. And then there was another change where these current regulations that have been out since 2001 were updated again in 2018, and for claims that were first filed after April 1st of 2018. So we refer to the ones in 2001, for those of us who have been doing this a while, as the new claims regulations, because the ones before that still apply to old claims if they're still around, like somebody filed for disability before 2001. Their claims would fall under the old regulations, which is a little different. Then there's the new regulations in 2001, and the changes in 2018, we call those the new changes. just to keep track of what's
Well,
going on.
and I know you're going to answer this, and maybe you can dismiss what I'm about to ask and say that's what we're going to talk about. Is there one set that's actually better for the consumer than the other set?
They keep getting better.
Okay.
So
Okay.
what was in the old regulations in the 1990s was longer deadlines for the insurance company to make a decision and shorter deadlines for you and people like you to appeal. So our clients had to only 60 days to appeal, and the insurance company had like 180 days to make a decision. Well, that got switched around. Under the new rules, once you file a claim, the insurance company has the deadline to make a decision, and they have to make a decision within 45 days for a disability claim, which are the majority ones we work with. They can get an extension of 30 days twice as long as they meet a couple requirements. That first of all, they have to send a letter during the first 45 days to say, hey, we want another 30 days. And then they have to give a good reason. It can't just be, well, we just haven't gotten done yet. They have to show that there's something beyond their control in order to get the other 30 days. And then they can do that twice. So no matter what, they have to make a decision within 105 days, period. But they really have to jump through hoops to even make it longer than 45 days.
How are we? I'm not used to these conversations where the consumer is actually getting stuff in our favor. Usually, that starts off really great, and then us humans and politicians and bureaucrats get
And
involved,
the
and it ends
insurance
up.
companies that rule the
And,
world, the giant overlord
yeah.
insurance
So
companies that actually make the rules, you just don't know about it.
yeah, how are we? Is this lobbyists that are helping us? Is this just pressure from the consumers, or is this we don't know? How are we getting these little wins? It looks like.
Yeah, so actually that's an interesting story that involved both political parties. So when Clinton was in office, he pushed the Department of Labor to write better claims regulations that switched from the really old ones, the ones back in the 1990s, but they didn't get finished until just before he left office and George W. Bush came in. And George W. Bush's administration effectively put in the regulations that were in the works. And those are the ones that came into effect in 2001. If you remember, George Bush was elected in 2000, inaugurated in 2001.
Yep.
And so he basically kept those claims regulations. They didn't get any better under Bush. They didn't get any better at all under Obama for a long time. Now, toward the end, Obama started writing, his people under him started writing new claims regulations, but he didn't get them finished in time to make them official while he was still president. So by the time he put them out, he said, I'm putting these out and these go into effect January 1st of 2018, which is 2 years after he was out of office. And when President Trump's administration came in, they actually said, well, wait a minute, we want to look at these Obama regulations. And then the only change they made was to say, We're going to change the effective date from January 1st of 2018 to April 1st of 2018 because now that we've had a chance to look at these are fine. Neither the Trump administration or the Obama administration is out to screw the little guy. They both were basically protecting employees, and part of the history is Donald Trump's original nominee for the Department of Labor was somebody who was a business guy, and he might not have been great for employees, but he didn't get through the nomination process. So Donald Trump instead put up somebody to be the Secretary of Labor who came from within the agency and was somebody who had a history of being pro-employee, and he got nominated and approved, and so he just went through the same regulations that they'd already been working on and approved them.
I'll be honest with you. I just don't know if we should stop the video now. Now that we found a place where Democrats and Republicans have actually kind of done something together to help us, I think we should just put this in the archive. But I'll let you continue on. I'll let you continue on, sir.
Right. So let's get back into the nerdy
Yeah.
steps. So
Yeah.
anybody who's got one of these claims, so you have to go look in your policy to see how long you have to file a claim. Normally, it's something like 90 days after the end of your elimination period. Well, what the hell's your elimination period? Well, that's the
Mhm.
first, say, 6 months that they don't pay your long-term disability benefits. For a long-term disability case, you've got 6 months where you don't get paid, and then you got 90 days to file a claim. Sometimes that can be extended. You got to look in the policy. For health insurance, it'll say how long do you have to file a claim? Do you have to file the claim before you go see the doctor? Do you have to file the claim after you see the doctor? Sticking with disability insurance, just to keep it simple, once you file that claim, that's when the insurance company has 45 days to make a decision.
The clock starts.
The clock starts. If they write a letter and give a good reason, they can extend it by 30 days, and they can do it again if they write another letter. So they really have 45 days to make a decision, but they can make it up to 105.
Okay.
After 105, what happens? Well, the rule is that the regulations say is deemed exhausted. Well, what the hell does that mean? That's that lawyerly language. What it means is this: one of the big rules that applies in ERISA cases is we can't take your case to court until you have gone through the whole appeal process.
Okay.
You have to appeal to the insurance company. If you don't appeal to the insurance company, you go straight to court. Judges will throw the case out, and basically your case is over. You've lost. So you can't just go sue the insurance company whenever you want to. You have to go through this appeals process. What happens if the insurance company misses the deadline? It's deemed exhausted, so your appeal process is over. Now you can go sue them. You don't have to keep going through the rest of the steps if you don't want to.
Wow.
But you can. Why would you want to do that? Because remember, when you get to court, the court is only going to look at what was submitted to the insurance company. So if you've got good evidence you haven't had a chance to turn in yet, you're waiting for your doctor to write a good letter, you're waiting for certain tests to come back, your lawyer, like, we'll send people out to go get a special exam, maybe a functional capacity exam, maybe we'll interview your doctor to get a good statement put in the record. You want to go ahead and submit all that to get it as part of the claim file so that the insurance company has to consider it. And so we can show it to the federal judge later on that this is what the insurance company had in front of it when they said that you were not disabled. So we've got to get that in. So the fact that that they haven't made the decision on time, that means you could go ahead and sue, but only if you want to because your file is ready.
Okay, and you may get to this. So what happens? We get to the 105th day, 106th day. I've been saving my big guns, and then
You don't want to. We won't save anybody's big guns.
that's what I'm saying.
We submit everything we can. The
That's what I
problem
was
we
getting
run
to.
into is that we have people who haven't hired an attorney yet, or they hired an attorney who doesn't normally handle these ERISA cases, and then they come to us and they say, "Well, the insurance company didn't make a decision on time." Well, let's see what you submitted to them, and we look, and it's a letter from the doctor saying that this person is disabled and maybe some medical records, and we're like, "Oh my gosh, no." We've got to do a lot better than this. We've got to prove this case. We're going to go get your restrictions, limitations from your doctor, not just a letter. We might get a functional capacity exam. We might hire a vocational expert. We might do some kind of a video interview of you, whatever is appropriate in that case. Take some pictures of your disability if it's something that looks visually disabling. Whatever it is, we want to submit all that. So normally what happens in the normal course of business is the insurance company denies somebody's claim the first time, and under the regulations, they have for a disability case 180 days to appeal. That is often when people hire us.
After that,
when they get the letter saying you're denied and you have 180 days to appeal, and the insurance
Gotcha.
company has to tell them they have 180 days to appeal. And why do they have 180 days to appeal? Because it says right so in 29 CFR 2560.503-1. One of the rules is they have to give you 180 days to appeal if you have a disability claim. If you just have a health claim or some other kind of claim, it's different. For other kinds of claims, it can be 60 days.
Mhm.
For healthcare claims, there's like 4 different deadlines, and we're not going to go into those in this podcast. I'm just
Yeah.
going to tell you that if
But
somebody
what
has a
it for
healthcare claim,
ERISA? It's ERISA,
they're all under ERISA.
right?
So if
Gotcha.
your health insurance is at work, that's an ERISA health insurance claim. If your life insurance is work, that's a life insurance ERISA claim. If you get disability at work, it's an ERISA long-term disability claim.
See, this to me is such a good reason. When you get the letter from the insurance company that says no, my first call wouldn't be to the insurance company. I would just call you people up and go, "Hey, can you read and translate what they are saying to me?"
Yeah, I mean, if you call the insurance company, it's kind of like if you get caught robbing the bank and you get to the police office and the police officer says, "I got some questions." You say, "Should I hire an attorney?" And the police officer says, "No, just answer the questions."
No. Why
No,
would
you
you
don't
do
need an
that?
attorney. You're gonna be fine. Just confess, and when you're in jail for the rest of your life, it'll be
Yeah.
fine.
All right. What's
You don't need an attorney. So the answer is yes, you need an attorney. Don't call the
right?
insurance company. Call someone like us who handles
Right.
these long-term disability claims. All right.
Okay.
So just as a comparison, remember when we said if you file a claim, the insurance company has they have 45 days to make a decision, which they can extend by 30 days. If it's just a claim like life insurance, they can actually make it. They have 90 days to make a decision, which they can extend by another 90 days. So there are other rules in here, and the attorneys have to know what they are in order to handle different types of claims. But we'll stick to disability cases because that's the ones we see the most and we help people the most. So the insurance company, like we said, 45 days so they can get two 30-day extensions for a total of 105 days. Then they have to give you 180 days to appeal. That's the opportunity, if you haven't done so already, to hire an attorney. And that
Ah.
gives us the opportunity to gather more evidence, talk to your doctors, get whatever we can to show what your restrictions and limitations are, whatever it takes to make that a good case. And we submit all that to the insurance company. Now, do we have to wait the whole 180 days? No, we want to do it as soon as possible. And we try hard to do it, say, within 90 days. But sometimes we have to wait for doctors because they're busy, they're on vacation, it's, whatever. It takes a while to get their medical records. It takes time to set up a schedule to talk to them. So it can take up to 180 days. That gives us time to do it right. But we also
Mhm.
don't want to take the whole 180 days if we can help it, because we know our clients are probably don't have any income or don't have much income, and these LTD benefits we're fighting for, that's going to be their income. So we want to get the evidence in as quickly as possible. And once we submit it to the insurance company, we say, here's everything, here's our appeal, make a decision. And once we tell them to make a decision, now they have another deadline. They have 45 days again, and they can only get one extension of 45 days. So they have to make a decision within 45 days. If they don't make the decision within 45 days, they have to write a letter and give a good reason that's something beyond their control why they need more than 45 days. Now, that's the basic process. And at that point, when the insurance company makes a decision, then we can take the case to court. Now, in 2018, when they added some new rules, they did a couple of important things. One of the things that they said is if they get any new evidence during that appeal process, during those 245 days at the end, they have to share it with us so that we can comment on it. They can't just sandbag it. They can't just add new stuff to the record, and then the first time we ever see it is when they send the final denial out. So
Gotcha.
that's some good news and something we can hold them to. One of the other issues is when this gets a little confusing, but I want to make sure we cover this, is the standard of review when the case goes to court. You and I have covered this in other podcasts, but the base.
Ladies and gentlemen, real quick, the reason I'm smiling is he goes, "This could get a little confusing." You're going to start hearing Eric talk really slow to me because he knows my brain. He's I was smiling because Eric like, "Okay, Clint, here we go. If Clint can understand it, anybody can understand it. All right, give it a shot, dude."
But at least you're good looking, Clint. That's
I'm
one of my
trying, dude.
favorite
I'm trying.
parts of these
That's right.
podcasts. Yep.
All right, let's hear it.
So what the Supreme Court said in 1989 in a case called Firestone Tire versus Brudge is that when you sue an insurance company under ERISA, that the default rule is that the insurance company's case will be reviewed under something called de novo standard of review. So the court's going to look at your fight against the insurance company de novo, which means the court's going to weigh the evidence the insurance company wants to look at. It's going to weigh your evidence, and the court's going to make its own decision as if it was the de novo decision maker. That's the default rule. However, in Firestone Tire versus Brush, Justice Sandra O'Connor actually put into the opinion something that has totally changed the world. And what that was she said, but if the policy grants discretion to the decision maker, and actually what she said is if the parties agree on a grant of discretion, well, who are the parties? It's your employer making a deal with the insurance company when they buy the policy. You don't have any choice in this matter.
I'm out.
You're out. You just take you get hired, you sign up for your company insurance, and you get what you get through your company
Right.
insurance. Your employer and the insurance company have made a deal that includes discretion language in the policy. It includes language that says if the insurance company denies your claim, when it goes to court, the court gives the benefit of the doubt to the insurance company. And in fact, the way that some courts describe it is the insurance company can win if they're wrong, as long as they're not unreasonably wrong. Some courts have even said they can be downright unreasonable.
Wow.
So as long as they are not downright unreasonable, they win even if they are wrong under the arbitrary and capricious standard of review, which has to do with this magic language. But there's good news, Clint.
Dun, dun, dun.
If the insurance company breaks one of these new rules that's been in place since April 1st of 2018, and your claim was filed originally after April 1st of 2018, then they lose their discretion. There's real teeth in these regulations that say for people who filed a claim after April 1st of 2018, if the insurance company breaks one of the rules in the regulations, then your claim is reviewed de novo. You
That
get the
means
old good review where all the judge does is weigh your evidence against the insurance company's evidence and figure out who's got the better case. So if you have a case where you win even by 50% to 50.1% to their 49.9%, you still win. It has nothing to do with whether the insurance company was reasonable or not. Now, if you don't have a violation of the regulations and the insurance company does have discretion, often the court's going to apply that discretion. We can talk about a different podcast. Some states have also tried to ban the discretionary clause, like
Yeah.
Michigan and California have done that so that the insurance company can't apply that rule to their citizens. A lot of states haven't done that. So a lot of ERISA cases still go to court under what's called an arbitrary and capricious standard of review, especially if people don't have an attorney help them through the claim process. But if we have somebody who filed their case, their original claim with the insurance company was filed after April 1st of 2018, and the insurance company breaks one of these rules, and it's not just the time deadlines we've talked about. We'll talk about a few other rules before we get done today that they have to follow. If they break one of those rules, then we go to court and we get the good version of the standard of review. We get the de novo standard of review.
And just for everybody, once again, the reason Eric pre-qualified, or he said that little throwaway comment about that's we can talk about this in another podcast. He knows daggum good and well I was about to go down that rabbit hole, and he was getting in front of that horse. That's what he was doing. He was like, I'm gonna stop my buddy Clint from going, hey, wait a minute. So
if we talk about the state, we'll talk about the state. The standard review is worth doing as a whole separate podcast.
I have questions on that, but I know we got other things to talk about for this podcast or this video especially.
The important thing to know and to remember is that the standard of review that you want to have to apply to your case is de novo. But there's all too often the insurance company will have the magic language in their policy and they won't mess up somehow. And there's no state law to save you. And so you go to court and the insurance company gets the benefit of the doubt and they win even if they're wrong, as long as they're reasonable about it under the arbitrary and capricious standard of review.
That's just mean for you to do it twice. You said it twice, and I can't ask a question. Just keep going to the next thing, man. Now you're frustrating me a little bit.
So let's talk about. Well, go ahead. Ask you. There might be people listening.
It just seems to me that we ought to have a point in time where the good rule just becomes the rule. I mean, it seems silly to me to have the bad rule for consumers, and then there's the good rules for consumers. And if everything goes wrong for the insurance company, then we can use the good rules. That just seems a little silly. Is there an advocacy group I should start or something?
The problem is, and this is why I didn't want to go down this rabbit hole, is
See?
'cause the solution to this problem is to get Congress to pass a law that says that these cases should be reviewed de novo. There has been some talk in Congress about it, but the problem is there's not that many people in the big scheme of things that have a disability case or some other kind of ERISA case at any given time, and it's just hard to get the attention of enough
I
congressmen to
get
get
you.
the law changed. And if you try to explain how this works to typical congressmen, which I've tried to do before, it's just not something on their radar. So it's not something that they, when the border's being overrun or the
Yeah.
any of the other things that are going on in the
Pandemics around. They've got stuff that I
there's
get it. That
yeah,
yeah.
they got to deal with pandemics. They got to
Yeah.
deal with the voting rules both sides are trying to
Yeah.
change. Whatever it is that they're on about, the last thing that somebody's going to get their attention with is whether or not the ERISA benefits claims needed to be decided under a de novo standard of review.
Okay, I'm going to do something very odd for any conversation that Eric and I are involved in. I'm going to pull us back to topic, Eric, and that is the other rules and regulations that we need to cover today. Which that this will be a first, but go ahead.
So this is actually some of the stuff that's in addition to following those deadlines. What else does the insurance company have to do? Well, when they deny the claim, they have to give some specific information. And this stuff sounds a little technical, but it actually matters if you know how to read it. So they have to give the specific reason or reasons for their adverse benefit determination. So you file your claim, they say no, they have to give specific reasons. They can't just say, well, you're denied. And they really shouldn't say you're denied under the policy. They should say you're denied under the policy because what's the specific reason? It needs to be something that you can understand how to appeal. They have to reference the specific plan provisions upon which the determination is based. Where in the plan does it give them the rule? Where in their insurance policy does it give them a rule that says this is how they're allowed to deny your claim? They have to tell you what, and here, let me read this. A description of any additional material or information necessary for the claimant to perfect the claim and an explanation of why such material information is necessary. So instead
Mm.
of just saying you're denied under our rules, they have to tell you, and in order to win, you have to submit this, and here's why you have to submit this. That's right there in the rules.
So they have to say if they're going to deny you, they have to tell you why, where it's at in the claim, and then specifically the remedy of that on your end as the consumer.
Yeah,
Okay.
why, where it says it in the plan documents, and then what you can do to fix it.
Okay.
Then they have to tell you what your rights are, like how long you have to appeal, that kind of stuff. Because the 180 days is actually the minimum for disability cases. They could actually give you more time. They just can't give you less than 180 days. And then they have to do things like this one's, I'll just read this one. It's just interesting because it comes up sometimes. In the case of an adverse benefit determination by group health plan, and then also by reference to disability plans, it says that the regulations, if an internal rule, guideline, protocol, or other similar criteria was relied upon in making the adverse determination, either the specific rule, guideline, protocol, or other similar criteria, or a statement that such a rule, guideline, or protocol, or other similar criteria was relied upon in making the adverse determination, and that a copy of such rule, guideline, protocol, or other criteria will be provided free of
Mhm.
charge to the claimant upon request. What's that mean in plain English? If they have some other rule that they follow internally that's not in their policy, they have to give you that rule too.
I just need to tell you, I don't even need your services right now, but I just about stopped listening just to call your office and get them on the phone with you to hey, your boss is saying something. What is he trying to tell me? I quit listening about 2 sentences in, man.
Yeah, it's
But
that's the
again, that's
technical
another
stuff.
reason.
But yeah, so I mean, again, what that boils down to is if they have an internal rule that they're not that they haven't told you about before, they have to tell you that they're following that to deny your claim.
But again, I mean, if I were getting that, I would have read it more carefully and given it more weight and credence. I understand that, but I just want to say it again, sprinkle it in throughout this conversation. That's another reason I believe in calling somebody like you who can read that and quickly translate it rather than me thinking I get it right, because that was a lot of words to say few things, one little thing.
Yeah, that's bureaucratic. That's what it's in a government regulation, Clint. So it's good.
And it's not by
That's what they
accident.
They get paid to do it that way.
Yeah, I'll just tell you, I don't think it's by accident. So,
It's even better because there's an or at the end of that paragraph.
golly, hold on. I'm just
Or
taking my headset off.
if the adverse benefit determination is based on a medical necessity or experimental treatment or similar exclusional limit, either an explanation of the scientific or clinical judgment for the determination, applying the terms of the plan to the claimant's medical circumstances, or a statement that such explanation will be provided free of charge upon request. In other words, if they're going to deny you for a special rule because they're considering your condition to be experimental or not, the treatment for it not medically necessary, they have to give you the specific rule they're relying on. That's what's kind of nice about these rules.
Yeah, I get it. I understand it's there for our protection. I understand that. But again, it's written in such a way to where I'd have to do a lot of deciphering. But go ahead.
So starting in 2018, for people who filed their claim after April 1st of 2018, and now that's over 4 years ago, that applies to a lot of our clients. They now, one of the new rules is they have to do things like they have to give in their explanation the basis why they disagree with, and then they have three categories: the views presented by the claimant to the plan, I'm sorry, views presented by the claimant to the plan of healthcare professionals treating the claimant and vocational professionals who evaluated the claimant. So they have, what that means in plain English, if your doctor provides opinion or if you hire a vocational expert to provide an opinion, they have to expressly, the insurance company has to expressly state in their denial decision what was their basis for agreeing with or rejecting those
You
opinions.
can't just say we don't agree with your doctor's statement. They have to tell you why they don't agree with it.
That's exactly
Right.
right. Um, if they have their own doctor or vocational expert that provides an opinion and that supports you. So if they go out and hire a doctor and that doctor says, yeah, actually, I think this guy's disabled, then they have to explain why they're disagreeing with that doctor if they're going to turn you down.
Do they have to? Okay, silly question. What happens if they interview a doctor that agrees with my doctor? Do they have to include that in the files, or can they just forget?
So the real life answer to that is yes, they better do that. But what if they just do that orally? They don't do that in writing? How would we ever know? That's one of the fights we get into with these insurance companies.
Okay, well,
Is
that's a
the
good
is that
question then.
they
Yeah.
could ask the doctor, "Hey, do you agree that this guy's disabled?" Well, actually, yes, I do. Never mind, don't send us a written report.
Mhm.
We'll just have this conversation on the phone, because what goes to court is the written claim file.
That's it. Yeah, that's what I was asking. I was like,
And so we will fight to try to find out as much of that information as possible, but it's one of the problems we have. The insurance companies in these cases, they get to put together the claim file, and if they have a conversation that doesn't get written down, we may never know
mm,
because
okay,
they can play that game.
all
But
right.
here, but let me give you the third category, that they have to give a reason. They have to give an explanation for their basis with disagreeing with the third category, a disability determination made by the Social Security Administration. So if our client has been found disabled by Social Security, the insurance company can't just say, well, we're not bound by Social Security. It's different rules. They have to explain why they've come to a different determination. And honestly, it's a little hard for them to do, because in order to be disabled by Social Security, you have to be found by the government to be totally disabled from not just your own occupation, but from any occupation that you can reasonably vocationally adjust to, which basically means you have to be disabled from any occupation to win your Social Security case.
Hmm.
There's special rules under Social Security for people that are over 50 and 55 that say, well, we're not going to make you do a totally different type of job that you've never done before. But the basic rule under Social Security is you have to be disabled. You have to be unable to do a
Right.
regular occupation. Well, if that's how disabled you are, that Social Security has said you're disabled, the insurance company better come up with a darn good explanation why they think they can say you're not disabled if Social Security said you are
When
disabled.
the government says you are.
That's a great new rule that went in place in 2018.
All right. See, we're winning more than we're losing on these new rules. Okay, what
Yeah,
else we got?
and honest to goodness, Clint, this is thank you President Obama and thank you President Trump. They both together put these rules together and decided to keep them in place, or at least the Department of Labor under both administrations did.
Okay.
Um, there's other rules in here that they have to provide the guidelines again that they're following, and they have to provide you a complete copy of your claim file of all the records that they base their decision on if you request it. And that's something we do for all our clients, is we request the claim file, we request the record so far. But you can do that on your own before you hire an attorney if you decide to look into this a little bit. I always suggest people just hire us and we'll order those records. But it's a right that individual people have to do. If they deny your claim, they will tell you, they have to tell you in the letter, you have the right to get a copy of your claim file.
Okay.
All right. Then you have the 180 days if it's a long-term disability case. It's 60 days for some other kinds of claims like life insurance. It's different rules if it's health insurance. But once you appeal, they have to give you that time to file your appeal, and then once you appeal, they have to provide what's called a full and fair review. They have to so a full and fair review has to give you the opportunity to submit written comments, documents, and records. That they have to again give you a copy of the documents that they relied on. They have to take into account all of the comments from the doctors that you submit, and then they have to make their decision. And that decision, like I said, has to be made within 45 days of you submitting your appeal, and they can extend it by 145 day extension.
Right.
It can be 60 days that they have to make a decision if it's like a life insurance case. And again, now here's one of the new rules. If they add new documents to the file on appeal, like they go get another doctor to look at it, they have to send that to you or to us as their attorney in order for us to comment on it before there's a final decision made. And then again, they have to issue a final decision, and it has some of these same rules. They have to give the specific reason for the adverse determination. They have to reference the specific plan provisions. They have to tell you that you have the right to get any internal documents or rules. If there are any voluntary appeals, they have to tell you if those are available to take another appeal if you want to. Well, why would you want to do that? Well, sometimes people come to us and they did the appeal on their own and their record is not very good. What was submitted is not what we'd like to see in there, so we can add more stuff. The danger is, and this is the big watch out, not every plan has to give you a voluntary appeal. In fact, a lot of insurance companies say once you file that first appeal and get denied, you're done. And now the record's closed and we're not going to consider anything else. So it's really important to hire an attorney to call us before your 180 days is up, and in fact to do it at the beginning of that 180-day period so we've got time to pull it all together.
Well, I was going to say, it seems, and this is where you can clean my thinking up. It seems like deadlines and extensions and 45 days for this or 60 days for this, seems like that used to be something that could be leveraged more for the insurance companies, because if they push the deadline and somehow they can get past that deadline, all of a sudden it defaults to them being, they're in the big chair. But now it seems like there's really no reason for them to push deadlines and kind of use that time as much as possible, because at some point in time, it's as much a benefit to me if they miss the deadline. It's more of a benefit to me if they mess around and miss the deadline, because now we're playing by the same rules.
Close. Let me clarify something.
That's why you're here, man.
If one of our clients misses the deadline before they come hire us, or God forbid we miss a deadline, which we obviously that's what we do for a living, so we don't do that. Knock on wood. But if a claimant on their own misses the deadline, their case is over. They've lost their case. They don't have any rights anymore. Period.
Wow, I'm glad you cleaned that up, man, because that
if they miss their deadline. If the insurance company misses their deadline, then the case isn't over. It just gives you the right to sue them sooner. And under the
but it goes back to that. It depends on what you have in the file at that time.
Yeah, it depends on what you have in the file at that time. But also if they miss the deadline under the new rules, it means you get a de novo review where the judge is no longer going to give the benefit of the doubt to the insurance company. It doesn't mean they automatically lose.
No,
But the balance is, though, if one of our clients misses the deadline before they hire us, or an attorney doesn't know about these deadlines and misses them, the claimant loses and their case is over.
Wow.
There's no second chances.
Man,
now every once in a while there's some arguments you can make about whether they got the proper notice and stuff, and we've had to fight that fight before. But under the rules, if somebody knows what their deadline is and they miss it,
I have a question, man.
They're screwed.
I have a question on the notification thing. Is it only by mail, and is it signed? I mean, is that because I've changed addresses before and had an issue with getting notifications. Does emails count? Do phone calls count? What counts as notification?
The term notice or notification means the delivery or furnishing of information to the individual in a manner that satisfies the standards of 29 CFR 2520.104B, which basically means they have to send it in mail to your last address, but they can actually get away with sending it to your email address under certain rules.
Okay. Your nerd just came out there, man. Just want you to
Well,
know you're
I was actually had that section of the regulations pulled right up when you said.
that's great questioning. Then I can't believe I asked that because that's a big deal. I've moved twice in 3 years. And so because of that, if I had an
So
issue,
what
then
they'll do though is when they mail it to the last address that you had with the plan. So if you move when you become disabled, or you move while you have a healthcare fight going on with your employer, make sure your employer knows your new address,
wow, that's a big
because they
deal.
could
Yeah.
send it to the last address you told your employer about, and they'd probably be okay. They could deny you that way, and you
Okay.
not get the notice.
Okay. What else do you got before I tell you one thing I've learned today? But go ahead and you still have the ball. So you have the ball.
So there's a few other rules in here that are not that as important, but essentially one of them is they have to write the decision has to be either in standard English or in the appropriate language. They actually have to offer you a chance to have it translated into the language that you speak. And then one of the other things that in here that says if they miss the deadlines or otherwise don't follow these rules, there used to be a rule called substantial compliance, which meant if the insurance company just kind of screwed up a little, they still didn't lose their discretion and they still got the full benefit of the rules. And the new regulations that went into effect that were written under Obama but went into effect under Trump, both administrations supported this, basically say no, there's no such thing as a substantial compliance violation, that the violation has to be so small it's called de minimis, which is a legal term for it really is a tiny technical violation. But the standard for meeting a de minimis, for having something be a de minimis violation, is really hard to meet. And so the result is if the insurance company misses their deadline or does something else significantly wrong under the regulations, there's a good chance, because we know how the rules work, that we're going to be able to show to a federal judge that we should get the good kind of review in court, that we should get de novo review, not the arbitrary and capricious standard review, which is the one that's in favor of the insurance company.
Okay. All
What'd
right.
you learn today, Clint?
So I've done 4,237 of these conversations with you, give or take one or two. Who's counting?
Somewhere between 2 and 4,527.
Yes. But I have this is just my pea brain. This is when Eric goes, why is this guy on the video with me anyway? So this is the first time when you said ERISA, I always assumed that ERISA was something specific to the disability component, not also the health and the life part of it. Isn't
It's
that
health,
weird?
it's health and life and dental and
Yeah.
all those benefits you get at work.
You said that like
That, that,
40 minutes ago into this thing, and I was like, well,
and
it's ERISA. It's not
and
just disability.
it finally clicked in your head that I've been
It's
saying that
20
all
years
along.
later, and I'm learning. You're doing a great job, Eric. Good job, man.
ERISA applies to health insurance, life insurance,
Yeah.
long-term disability, pension benefits, any of those things that somebody gets at work.
All right.
The Federal Employee Retirement Income Security Act of 1974, which is coming up on its 50th birthday in 2
That's a
years.
good time to reshare that video about the history of it. Hey,
Yeah.
do me a favor. Tell everybody, if I know that they're probably watching this maybe on your website. I don't know where you guys are putting this stuff. Tell everybody where they can find you, though, just in case.
Yeah, just in case you're watching this on YouTube or somebody shares this video with you, it's Eric Buchanan Associates, Chattanooga, Tennessee. We handle disability insurance cases all over the United States. We work with local attorneys where we need to. We're licensed in several states. You can look at our website for a full list of where we're licensed, but we will work with other local attorneys where it's necessary under the rules. So we'll handle these disability insurance cases anywhere in America. Find us on the web at buchanandisability.com. And reach out that way. That's probably the easiest way to find us.
Man, I appreciate you letting me be part of this, dude. Thank you.
Thank you, Clint, for helping.
It's always fun, man. Have a good day.
I love your
Bye,
backdrop there. Very solid. Yeah.
It's better than my podcast studio that looked like a podcast studio. So I was trying to fancy it up for you.
Good job, Clint.
See you, buddy.
Thanks. All right.
Bye, everybody.